I developed a new technology at university that I'd like to patent. I did not use any external money, therefore I want to file the patent myself. Since the details of the tech are not yet fully examined and I need more time to develop, I decided to file a provisional patent application. I have two open questions. How far should I go into detail compared to a real patent? I'm going to take this first question first.
I have another question I'd like to tack onto that.
Sure.
Should I hire a patent attorney?
That's yes.
That's a yes, right? I mean, yes, come on, this is complicated, right?
Especially when a couple things on this that just, I hate them. There's no such thing as a provisional patent. There's a provisional patent application, okay? And that's important to understand the difference. You don't get any rights by filing an application. Secondly, a real patent, well, likely what that means by there is a utility patent, the non-provisional, the formal application. It is still a good question. A couple of different things to bring up here. When you're co-developing an invention with the university, usually, probably like 95% of the time, there's a professor, a researcher, someone else that's an employee of the university that will claim co-inventorship. That's usually why you're there. Possible that you're yourself a professor, you've actually independently invented it. They've at least got some resources they're providing. So
yeah, universities put a lot of money into research and development. And
yes.
Anything that comes out of those, laboratories is theirs.
Yep. So I think it is odd that you as an inventor are filing this apart from the university. That just doesn't seem right. I would question whether and why the university itself is not filing on your behalf, why they're not hiring their own counsel to help support you. That's the route to go. They likely have almost zero financial interest in exploiting it commercially. They just want to have a license back to continue researching it. So I'd love to hear more about why you're filing independently, why you think you're kind of skirting. I think that's only going to cause issues. Filing provisional is a good idea, especially if you think more development is needed. It's the exact reason why you want to file provisional, to do more testing, tweak it, so you can add in more detail. You can't add new subject matter. But as long as you're refining, adding more detail, getting more granular with respect to what the invention is, that's what this time is for. So yeah, I would say hire an attorney, especially for reviewing inventorship, ownership, and then also look into preparing for the utility properly.
Hey, right. JD, how long can you stretch out a provisional patent application?
1 year. So you file it May 29th, 2024. You've got to file it by May 29th, 2025.
Now, you have to file the non-provisional.
Correct. If you do not publish during that period, let's say you kept everything under wraps and you're still developing it, it is possible to file a new provisional. And basically, as long as you didn't publish it or talk outside of a confidentiality agreement, you take the risk that no one else has filed it during that year. And you can start doing new provisional if you got more stuff. Still a decision as to whether you publish, sell, or take to a trade show.